Hello, everybody. It looks like all of our panelists are now here. Brendan, can you hear me?
I can hear you, Jonah.
All right, great. I see Justin, Claudia, and Sarah. All right, so let's get started. All right, so if you've been to a grocery store in the last few years, you've probably noticed an explosion in vegetarian or vegan substitutes for animal-based food products, from oat milk and almond milk, to Beyond Burgers and Impossible Burgers, to eggless mayo made with pea protein. Some people claim that these alternative products are healthier, others claim that they're better for the environment, and others find them more ethical than animal-based foods. In any event, there's never been more consumer choice in the grocery aisles. At the same time, there's been a corresponding explosion in regulation and calls for regulation of how these new products may be labeled and advertised, including the fundamental question of what names manufacturers can use for these products. These regulations vary in terms of what they require and what they forbid. For example, just days ago, Oklahoma's governor signed into law the Oklahoma Meat Consumer Protection Act, which requires plant-based meat alternatives to state on their product packaging that the product, quote, is derived from plant-based sources in type that is uniform in size and prominence to the name of the product. So that's a disclosure type law. Other states have gone further. For example, last year, Arkansas passed a law flatly prohibiting companies selling plant-based meat alternatives from using words like burger and sausage to refer to their products, even if those words appear in phrases like veggie burger and vegan sausage. In the last 2 years alone, 30 different states have proposed or enacted laws like these, targeting plant-based meats. Analogous laws have been passed or introduced in a number of states targeting plant-based dairy alternatives. Similar bills have been introduced recently at the federal level, such as the Real Meat Act and the Dairy Pride Act for meat and milk, respectively. And the past commissioner of the FDA, Scott Gottlieb, said that the agency plans to issue guidance on the use of the term milk in plant-based dairy alternatives, after famously noting that an almond doesn't lactate. These laws and regulations have raised a fair amount of controversy. On one hand, some argue that they're necessary to keep consumers from being deceived or confused about these novel food products, which can be quite different nutritionally from the traditional foods that they're emulating. On the other hand, some argue that these laws are just economic protectionism intended to shield powerful industries from legitimate competition. Of course, these motives aren't necessarily mutually exclusive, and again, not all of these laws and regulations are cut from the same cloth. Brendan, I'll turn it over to you.
Thanks, Jonah. Good afternoon, everybody, and thanks for sticking with us to the final presentation of the conference. I'm Brendan Healy, and I'm with Baron Harris Healy in Chicago. So as you might have guessed, these attempts to regulate have triggered a wave of First Amendment challenges. And some of these challenges have succeeded. For example, last December, a federal court handed the Tofurkey Company a victory by preliminarily enjoining Arkansas's truth in labeling law for meat products, which prohibited, this is the law that Jonah mentioned, which prohibited Tofurkey from using the phrase veggie burger. This law, by the way, got a lot of attention because it also prohibited the use of, quote, cauliflower rice, but not, quote, riced cauliflower. Similar suits have been filed in Mississippi, Missouri, and California, among other jurisdictions. Notably, although the sudden proliferation of these laws is a new phenomenon, the basic idea of regulating what food companies can call their products is not. For almost 100 years, the FDA and US Department of Agriculture promulgated what are called standards of identity. And these standards specify in great detail what various food products may or may not contain. There are more than 350 of these standards of identity for products ranging from milk to chicken cordon bleu. I think there are, for example, about 3 dozen on cheese alone. For generations, the courts, including the US Supreme Court, routinely enforced these standards without any question of their constitutionality. But in light of shifting commercial speech doctrine, even these long-standing regulations are now being questioned. Our panel today will explore this debate from several perspectives. And so with us, we have Justin Pearson, an attorney with the Institute for Justice, who's brought a number of lawsuits challenging these food labeling regulations. Justin was the lead attorney for Ochese Creamery in a case involving use of the phrase skim milk. And he is also the author of the article Censorship and Sensibility. I think this area, by the way, lends itself to clever article terms, and I think Justin hit a home run on that one. That article and the 11th Circuit opinion on Ochese Creamery are in your materials. We also have Sarah Roller, chair of the Food and Drug Law practice at Kelley Drye. She's represented the National Milk Producers Federation in an FDA proceeding seeking to enforce traditional naming requirements for dairy products. Sarah is a registered dietitian, so food safety issues are of particular importance to her. Finally, we are also joined by Claudia Haupt, an associate professor at Northeastern University School of Law and an affiliate fellow with Yale's Information Society Project. Her upcoming article, Public Health Originalism and the First Amendment, discusses the historical underpinnings of some of the food safety disclosures that will undoubtedly arise in our discussion today. As I mentioned, this is the last presentation of the conference, and frankly, given the subject matter of the presentation, if we were all together, I would suggest that this would be an excellent time for an ice cream break. But instead, we're going to dive right in. First, we'll hear from Justin about his experience with these issues in the trenches. Then we'll hear the same from Sarah. After that, Claudia will help us consider the issues from her perspective as an academic. We hope you find the discussion interesting and informative, and maybe next year we'll get some ice cream. So Justin, I'll hand it over to you.
Thanks, Brendan. Thanks, Jonah. Thank you all for having me. It's an honor to be here. As was already mentioned, I'm an attorney at the Institute for Justice. For those who don't know, IJ is a national public interest law firm. What that means is that I never sue for money, and I never charge my clients anything. Instead, thanks to IJ's over 8,000 individual donors, how I spend my time is that I go around the nation providing pro bono representation to small business owners in cases where I ask judges to throw out unconstitutional laws so that my clients can start their business or expand their business, or in the case of food labels, tell the truth on their labels using the plain language that consumers understand best. I'm going to talk about two of those cases today. Before I do, I want to give a little bit of additional brief background on what was discussed already in terms of the landscape with all these new laws that are being passed that regulate things like veggie burgers and could potentially regulate things like almond milk and coconut milk. It's important to recognize really three things in terms of where things were before this trend started. The first is that all 50 states already have laws banning misleading labels, right? And no one was accusing the veggie burger companies or the almond milk companies of violating them for the most part. Obviously, there are exceptions. The second is that the federal laws also include these types of prohibitions. And I'm not talking about the standard of identity definitions and those regulations. I'm talking about just general prohibitions that say, regardless of whether you comply with the standards of identity, if you have a misleading label, that violates federal law. And the third thing is this push didn't come from consumer protection groups. It came from trade associations. And there's nothing wrong with trade associations. You know, I'm not saying they're bad or that the people who work for them are bad, but they're doing what's in the best interests of their members. And so whenever a law is being pushed by a trade association where they're the only ones pushing it, and what they're asking for is for the government to regulate their competitors, and no consumer groups are pushing for that same law, like that should raise a big red flag. Now, in terms of the fact that there was no real problem going on, you don't have to take my word for it. There were a series of cases brought by class action lawyers and plaintiff lawyers, usually over non-dairy milk issues, that actually fleshed this issue out in the courts. And routinely, the courts would rule that no one is being misled, no one is being confused by terms like almond milk and coconut milk. There are quite a few of these cases. In the interest of time, I'll just quote from one of my personal favorites. This is a federal court in California that dismissed a class action case in an almond milk case. And it says, quote, "It is simply implausible that a reasonable consumer would mistake a product like soy milk or almond milk with dairy milk from a cow. The first words in the product's names should be obvious enough to even the least discerning of consumers. Under plaintiff's logic, a reasonable consumer might also believe that veggie bacon contains pork, that flourless chocolate cake contains flour, or that ebooks are made out of paper." And again, there are other cases that say roughly the same thing. And so it would make you think, well, wait a second, if the courts are saying no one's being confused, if the consumer protection groups are saying no one is being confused, if there are already laws at both the state and the federal level, including in all 50 states, preventing people from being confused, what's going on here? And on top of that, I should mention, it would actually be a disaster for these vegan food and non-dairy companies if people were confused about this, right? Their entire marketing approach is that they want to reach out to people who don't want to drink cow's milk, who don't want to eat hamburgers that came from a cow. And it would be a catastrophe for their businesses if people were confused about that. So they do everything they can to eliminate that risk or minimize that risk. And so it would make you think, well, so why are all these laws happening? And again, it's because these, basically it's because of a restriction on competition. You have trade associations whose members are upset about lost market share, right? You have the cattlemen's associations are mad that people are eating less beef and are eating more vegan burgers. The dairy farmers are mad, at least some of them, that people are drinking more coconut milk and more almond milk and more soy milk. I think my particular favorite example, and this was touched on a little bit in the intro, is the Arkansas Rice Growers Association. They pushed and got passed a law banning the term cauliflower milk while they simultaneously objected to a proposal to ban the term rice milk, cauliflower rice, while they pushed back to ban the term rice milk. And so there's no consistent principle here. It doesn't make the trade associations bad people, but they're doing what's in the best interest of their constituents at that time. They're not trying to pursue what's best for consumers or what follows any consistent, First Amendment jurisprudence. And so unfortunately, these groups tend to be pretty powerful and they tend to get their way. And what's kind of amusing to me is the officials who pass these laws don't even hide this fact. And I appreciate their honesty, but in a second, I'm going to talk about a case in Mississippi. And when the lead sponsor of the law banning the term veggie burgers was asked why he introduced a law banning the term veggie burgers, his response was, well, the Cattlemen's Association asked me to. That's not a good reason to restrict competition or to censor someone's speech, right? The fact that you want to help out your friends and protect them from competition is not a constitutionally legitimate basis for a law. But that's what's happening. That's what's happening on the state level. That's what some groups are trying to have happen at the federal level, although hasn't really successfully worked yet, but it might at some point. And so that's really what gives rise to these lawsuits. And again, I'm going to mention a couple of them. The first one I brought on behalf of these fine folks. This is Dan and Nicole. They own a vegan company in Chicago, a small business called Upton's Naturals. And even though it's a small business, they sell their vegan foods in all 50 states. And so the Mississippi ban on veggie burgers was a real problem from them. Now, just like all vegan food companies, Upton's Naturals make sure that their customers understand that the food they're selling doesn't come from animals. It would be a huge disaster for them if there was confusion over that point. And so they point out that they're on the front of their box that, it's 100% vegan, it's not made from animals, whatever they can think of to make sure that there won't be confusion. But it is important to them that they're allowed to use so-called meat product terms like burger as part of their description. And that's because that plain language is very helpful to consumers in understanding the characteristics of what's being sold. They don't want to follow the advice of a legislator in Mississippi who said they should call them vegan food discs. Like that doesn't sound very appetizing and it's not going to explain things to consumers. The way to explain things to consumers is to say, this is a veggie burger. That's a phrase that consumers understand. And they wanted to keep using that term. And so I represented them in a lawsuit in Mississippi last summer. And after just a few months, Mississippi threw in the towel, completely reversed its position and never began enforcing the ban. And now, Upton's Naturals and every other vegan food company can continue using words like vegan burgers and vegan hot dogs and so on. As you pointed out in the intro, both Brendan and Jonah, that's not a unique. We look around the country, there have been a handful of these cases, and one of two things always seems to happen. Either the government immediately throws in the towel, like is what happened in my Mississippi case, or in the one case where the government actually dug in its heels and fought back, which was the Arkansas Tofurky case. Arkansas obtained a preliminary injunction order where the district court ruled that they had a substantial likelihood of success on the merits of proving that Arkansas's veggie burger ban violated the First Amendment. And so when you think about why this is, right, when you think about why governments tend not to fight back to defend these laws, and when they do, they lose, a big reason why actually has to do with this person. This is a dairy farmer in the Florida Panhandle named Mary Lou Wesselhoff. She doesn't sell vegan products, doesn't really care about vegan products one way or the other. She sells all natural dairy products. She lives on her family farm in the Florida Panhandle. She also has a small creamery on her farm. It's called Ocheesy Creamery. It has 3 employees. And Mary Lou lives by an all-natural food philosophy. She hates additives. And her customers tend to hate additives too. And so Mary Lou still pasteurizes her milk, but that just means she heats it up. She refuses to add anything to her all-natural dairy products. And customers from far away will drive way out of their way to go buy their additive-free dairy products from Ocheesy Creamery and Mary Lou rather than buy the products with additives at their local grocery store. Mary Lou's like something out of a picture book. She's never had any trouble with regulators. She's never had any trouble with consumers. She's absolutely wonderful. But one day in 2012, she had an issue. A Florida regulator came to her and said, Mary Lou, there's a problem with your skim milk. Mary Lou's like, well, how could that be? You know, we milk the cows ourselves right here on the farm. We pasteurize the milk. We sell the whole milk as whole milk. We skim off the cream. We sell that as cream. The skim milk that's left over, we sell as skim milk. We do everything the right way. What's the problem? And the Florida regulator said, Mary Lou, you have to stop calling your skim milk skim milk. The reason was because Florida, as a matter of state law, and Ocheesy Creamery did not sell across state lines, so it was really only state law that was at play here. But as a matter of state law, Florida had adopted some federal regulations that had the effect of defining the product skim milk as having 3 ingredients. The first ingredient was skim milk. The other 2 ingredients, and that should tell you everything you need to know, but the other 2 ingredients were vitamins A and D additives. You could sell the skim milk without the additives. It would still be safe to drink. In fact, calcium is a water-soluble vitamin, which means it's in the skim milk, not in the fat. So it'd be safe to drink, healthy to drink, legal to sell. You just couldn't call it skim milk. You had to call it imitation skim milk. Mary Lou refused to do this. If you think about it from Mary Lou's perspective, so for someone who prides herself on never adding anything to her dairy products, you'd be hard-pressed to come up with a more harmful and controversial word to make her use on her labels than the word imitation. She spent 2 years trying to get the government to change their position. She met with the Florida Commissioner of Agriculture. He wouldn't help her. She met with attorneys. They said she had no case. This is the way things are done. She's not going to win if she fights. But she refused. She still sold cream, which meant she still had skim milk left over. But rather than mislabel it as imitation skim milk or imitation milk product, which was one of the other options they ended up giving her, she literally poured her skim milk down the drain rather than mislead her customers. And that went on for years, and it caused her quite a bit of money. Finally, after a couple of years, she found the website for my firm where I work, the Institute for Justice, ij.org, filled out a potential case form, and we looked into it, and we realized that she actually had more of a case than the initial lawyers that she spoke with realized. And briefly, here's what we realized, and here's why this precedent in the Ocheesy Creamery case has been so powerful in empowering these vegan burger challenges, and would also mean, I believe, that if these non-dairy milk laws were to pass and to start being enforced, they would also be unconstitutional. And so basically what we realized is, first of all, most of this precedent that people were looking to was promulgated during a period of time between 1942 and 1976. And that's really important, right? Because in 1942, that's when the US Supreme Court held that it would no longer protect commercial speech. The commercial speech was no longer protected by the First Amendment. It was later that same year that the first federal food standard identity lawsuit made it to the Supreme Court. And in 1976, the Supreme Court reversed itself. It said, actually, the First Amendment does protect commercial speech. As many of you know, that's the Virginia State Board of Pharmacy case, which was brought by consumer groups. Because what was happening was, as soon as the Supreme Court stopped protecting commercial speech, trade associations and other special interest groups went around and started getting laws passed to ban price advertising as a way of restricting price competition. Consumer groups fought back. The Supreme Court agreed with them. And starting from 1976 in the Virginia State Board of Pharmacy case, all of a sudden now the burden was on the government. Ever since then, there have been debates over what that burden should be. But the important thing was the entire judicial approach had changed from the approach that was in play when all of those standard identity cases made it to the Supreme Court. So that's the first thing to know. The second thing is, of course, we had to check to see whether that new approach applied to beverage labels. And it did, including in Supreme Court cases. I think the one I found most helpful was the case Rubin v. Coors, that was a case where the federal government had banned breweries from listing their alcohol content on their beer labels. And the idea behind that was that if you let people know how much alcohol was in their beer, consumers might pick the beers with more alcohol, and this could lead to a, quote, alcohol strength war. Supreme Court struck it down, said the same central Hudson test that now applies to most forms of commercial speech applied to beverage labels. And under that test, the government cannot ban companies from providing truthful information. And so we said, wow, that's great. That gets us part of the way there, but not all of the way there. Because if you think about it, what Florida was telling Mary Lou was not that she couldn't tell the truth. What Florida was saying was that they get to decide what the truth is. And if you use these words differently than what they say they mean, then you're misleading consumers, regardless of whether consumers are being misled or not. And so we had to find cases talking about that. There were no beverage label cases talking about that, but there were other Central Hudson test cases talking about that. The kind of the most famous one was the Peel case. That's a case involving a trial specialist where the United States Supreme Court struck down Illinois' adoption of an ABA model rule that said an experienced trial lawyer could only call themselves a trial specialist if they jumped through a bunch of additional hoops. Garrett Peel was an experienced trial lawyer. And what the Supreme Court said was, listen, Mr. Peel's an experienced trial lawyer. The public would consider him to be a trial specialist. The First Amendment protects his right to keep calling himself a trial specialist. Illinois' definition to the contrary doesn't matter. What matters is whether he's using one of the common understandings of the word, and he is. A few years later, there was another case called Ibanez involving a certified financial planner out of Florida, basically the same case, but for certified financial planners. And so we had this wonderful precedent that even though it didn't directly address food labels, it talked about the exact same commercial speech test that applies to beverage labels. And so we took that, we took the fact that most of the precedent was now based on an outdated approach to commercial speech. We took the fact that the court had said that under the Central Hudson test, beverage labels are protected and the beverage sellers can provide truthful information. And we took the fact that in other Central Hudson cases, the Supreme Court had said, truthfulness is determined by whether consumers understand it, not what the regulations say. And basically, this is an oversimplified version of our argument. Cases are much more complicated than this. But if you want the cites, there are the cases I'm talking about. We take that case, we go into district court, and we lose. But that's not surprising because usually when you do things for the first time or in a new way, it tends to give many district judges pause. And so we love appeals, not a problem. We go up to the 11th Circuit Court of Appeals. And I was honored to argue there again, like I had at the district court in front of the 3-judge panel. And there we win 3-0. And there are two things. Oh, and I should, by the way, just as by way of additional information, Florida didn't seek cert. Right now, if you go to Ocheesee Creamery, which is located about 40 miles west of Tallahassee, you can see that Ocheesee Creamery is selling skim milk with an honest label again. We since subsequently filed a lawsuit against the FDA challenging the federal version of these regs, at which point the FDA announced they were no longer going to enforce them. And more importantly, we no longer required states to enforce them. That's where most of the enforcement was happening. So we've actually not just made things better for Mary Lou, but for a whole number of dairy creameries around the nation. But there are two things about this Ocheesee Creamery case that are directly relevant to the veggie burger issue and the non-dairy milk issue. The first is the 11th Circuit adopted the Peel approach and the Ibanez approach and explained in rejecting Florida's argument that it was inherently misleading to call additive-free skim milk, the 11th Circuit explained that no, in order for the government to meet its burden of saying something is inherently misleading, they have to meet a very heavy burden that basically means showing that the way the term is being used does not comply with any of the common understandings of that term. It doesn't matter what the regulatory definition says. And so, of course, here, Mary Lou was selling a product that consisted of one ingredient. That one ingredient was skim milk. Like, it meets one of the common understandings of skim milk. It was not inherently misleading, which meant the rest of the Central Hudson test applied. And also, along those same lines, I want to point out, any issues over the characteristics of the milk or whether there be confusion with other types of skim milk, that's all what's called potentially misleading speech. And so that still is governed by the rest of the Central Hudson test. And the second thing I want to point out that the 11th Circuit talked about is something that directly contradicts and rejects the argument that we're often hearing now from the dairy industry. Because what's happening is, the dairy industry has pushed for years to get these terms like almond milk and coconut milk banned. I think they've realized eventually that that's not going to work. And the average consumer doesn't think coconut milk comes from a cow. And so they've become more creative and they've said, well, you know what? Even if the average consumer doesn't get confused about the fact that almond milk doesn't come from a cow, maybe they won't realize that almond milk has different nutritional content than dairy milk. And maybe that can justify banning the speech. And the 11th Circuit expressly rejected that type of argument because that's basically what Florida argued in our case. What Florida said was, yeah, even though Mary Lou's skim milk consists entirely of the ingredient skim milk, maybe it can be banned because consumers won't realize that her additive-free skim milk has different ingredients and different characteristics and different nutritional value than the other types of skim milk that have the additives. And the 11th Circuit said, if that's the case, then you cannot ban the speech. And what the 11th Circuit explained is that when it comes to potentially misleading speech, banning the speech must always be the last resort. The speaker and the listener get to decide the value of the speech, not the government. And if the government has an issue with that speech, if the speech is potentially misleading, the solution is to address that with supplemental information, not to ban speech. Banning speech must always be the last resort. And so the 11th Circuit pointed out that if it's true that Florida's concern is that consumers might not understand that Mary Lou's skim milk didn't have the same vitamin A and D additives as other skim milks, the solution isn't to ban the term skim milk. It's to accept her offer, which, by the way, she had always made and was willing to do this entire time, of actually saying on her label, this skim milk does not have the same vitamin A and D as other skim milks. There's no vitamin A or D added to this skim milk. The solution is to accept that offer, and as long as that can address it, there's no reason to ban it. It's for that reason, it's because of that case that the Arkansas District Court, along with other cases, but it heavily relied on No Cheesy Creamery, why it ruled in Tofurky's favor. And frankly, it's for that same reason, based on that sound logic from the 11th Circuit, that I think if the non-dairy milk ban were to pass, if the FDA were to start saying that almond milk can't be called almond milk and coconut milk can't be called coconut milk, that would also violate the First Amendment. I'll be honest with you, for just guilty pleasure purposes, I almost hope it happens because it would be so much fun to win the case. But if we're just talking about the right thing to do, it's pretty clear that it violates the First Amendment, and the FDA just should not do that. They should continue to let businesses use these common terms in context that consumers understand. Thank you very much.
Thank you, Justin. Now let's turn it over to Sarah. I have some questions for you myself, but I will wait until all our panelists have gotten to speak. Sarah, looks like you're on mute. There you are. Sarah, can you hear me?
Yes, I'm just about ready to hit share.
Great.
Okay, give me a sec here. Oops, I hit the wrong one. Here we go. There we go. Very good. Well, this is a very interesting situation I find myself in today. Good to be with you. As I said to Justin the other day, you know, having industry clients for my entire career, I often feel like I'm the Justin in a situation like this. But in this particular case, and I would like to mention that, for example, one of the cases I've worked on is a case called IDFA versus Amstoy, where the Second Circuit struck down a compelled speech requirement. And, you know, many of the cases and arguments that you just made were the sorts of things that were advanced there. But in this particular case, Justin and I are going to part company. And here's why. First of all, the Jonah mentioned earlier that that there's a petition pending, and this is pending before FDA, a citizen petition that we filed on behalf of the National Milk Producers Federation. And this is an organization that was founded in 1916, and the members are dairy farmers. They're dairy producers and also the dairy co-ops that they own. And the members of the organization produce most of the milk in the United States. The petition asks FDA to take enforcement and regulatory actions that are needed to stem the tide of nutritionally inferior non-dairy substitutes for standardized dairy foods, including milk, particularly the products that are derived from various plants. Used to be just soy, but now we have almonds, oats, rice, hemp, combinations, and all sorts of different plants. These substitutes are named using terms that have legal definitions like milk, and these are common or usual names. And these are, the common or usual name is sort of a term of art, but it's the name that you are required to use for a food, whether it's standardized or not. And the vast majority of these non-dairy substitutes are nutritionally inferior to the dairy food that is referred to in the name. And we're not talking about a small margin, like just one nutrient. Justin mentioned A in the case of the Ochese case. We're talking about very significant differences. Milk and dairy products, but milk, of course, is the source of the dairy products, is one of the most nutritionally dense foods that we have, and our national dietary guidance is recommending that people consume dairy products in order to meet their nutritional needs. There is only one plant-based alternative that dietary guidance allows to even be put in the same category, and that would be fortified soy. None of the other products have sufficient nutritional value to be placed in the same category with milk. So what does the petition ask for? The petition asks FDA to take 2 actions, both of which involve disclosure requirements, factual, non-controversial disclosure requirements as those terms are understood in the First Amendment law. First, the petition asks FDA to enforce existing imitation labeling requirements with respect to non-dairy substitute foods that are named using the standardized food name as part of the name. And I'm going to use for today's example milk. So the example you see is hemp milk. So if you use the term hemp milk, you're drawing a comparison to a standardized food, and that triggers the obligation to say it's an imitation milk if it is nutritionally inferior. If the product does not use a standardized term, let's say they call it hemp drink or hemp beverage, and there's nothing else that's really making a comparison, well then there's no imitation labeling required. And there are many ways they can truthfully describe their product without using a legally defined term. If the product does not use, in addition, note that the imitation disclosure statement is not required if the non-dairy substitute is nutritionally equivalent. I've already given you an example of soy, for example. In this case, FDA policy requires a different kind of qualifying statement. So instead of it being hemp milk, if it's nutritionally equivalent, it would be combined with milk substitute or milk alternative. This conveys that this isn't a blend of 2 or some combination. There's no equivalency suggested, but it is a different nomenclature. The petition also, and so these would be rulemakings to codify this, because FDA's policy is actually under the common or usual name rule. And we find that some of the policies that seem very straightforward sometimes don't get the attention they deserve. And so we're suggesting that FDA codify that also in the imitation rule. The amendments would only apply to dairy foods. This is not to reach out and touch any other category of standardized food or substitute. And then we are proposing that in the petition that there be one additional option available, and that is that if a nutritionally inferior food, if the maker would prefer not to use the term imitation, which has a legal definition, there would be the alternative to disclose instead the nutritional inferiority of the product and the other material differences, which are pretty extensive. And that would be required, the disclosure of material facts as part of the basic anti-deception provisions of the Act, and something that FDA has applied in the context of standardized dairy foods. So I just want to point out that there are several provisions of the Act that bear on the question, how do you name a food? I said earlier, the common or usual name is the name to be used, if any there be. Food must not purport to be or be represented to be a standardized food if it is not a standardized food. And the food must be accompanied by the term imitation if it's an imitation of another food. So when it comes to naming standardized foods, we have one standard that was adopted by statute, but the others are adopted under Section 401 of the Act. This is an important section. Section 401, notice that it says that the standard of identity is to be connected with the common or usual name. So this is not something FDA makes up. It's something that has to meet the common or usual name standard, and then you develop the standard in conjunction with that. Something very important to know is that standards of identity are not just about knowing whether it came from a cow or an almond. They actually come from a long history. I mean, probably since human beings were making food, we've had issues with economic adulteration. But particularly in the 1800s, about 1850, when industrialization and urbanization started, it got to be increasingly challenging. And some of you might be aware of a very famous public health case involving swill milk, where the distilleries decided to try to start dairies, and we wound up with cows that were eating the byproducts of a distillery and not producing very high quality milk, in addition to it being unsafe for bacteriological reasons. But importantly, because it didn't have very much fat or nutritive value, the makers of that product, were adding things like talcum powder and other things to make it look more like milk. And, that was just a very famous case. A lot of people died. And over the years, until we got our first law, the 1906 Pure Food and Drug Law, there was a lot of concern about this. And it was hoped that the 1906 Act would be able to deal with this. And there were provisions, but as FDA explained, ultimately the 1906 Act contributed to the proliferation of cheap and debased foods, and the government was handicapped in its ability to maintain the integrity of the food supply by making it difficult for the government to take action against a debased food product. Eventually, the government and industry came to the conclusion that a new statute was needed, which is the 38 Act, and was needed to ensure the integrity of the food supply by keeping economically adulterated foods off the market. And a critical piece of this was the adoption of Section 401. And 401 relates to the imitation. So you want to see these as interrelated. But the issue has to do with the integrity of the food supply, having nutritional density in the foods, and to anchor that so that when there is economic adulteration or an inferior food, that there's actually a benchmark to compare against. So here's an example of part of the milk standard. And I just want to flag for your attention, because nutritional science really is a relatively new science, in the sense that, it was in the 1930s and 40s that nutritional deficiency diseases were being discovered. But even so, the original standards did have these criteria that related to milk solids and milk fat. And that's why I mentioned the swill milk case, because milk solids and milk fat, that's what you have when you take all the water out. That's where all the nutrients are. So even in those early days, and we still have these standards, just those criteria relate to this issue of nutritional integrity, food quality. The standard also provides for the option to add vitamins A and D. And for many years, FDA has had this policy that standards of identity will have an option for a fortified version and one that is not fortified. I think your case involved 130.10, and that is a newer rule which allows for the nutritional modified version of the original. So this is a case where you're going to use a nutrient content claim, and the rule allows you to deviate from the parent standard to the extent needed to meet the requirements of that nutrient content claim. So, for example, the milk fat level could be lower if you're going to be making a reduced fat or low fat milk. But there is a requirement that the product not be nutritionally inferior. So one of the things that happens when you take fat out is you're going to take vitamin A out, because vitamin A is a fat soluble nutrient. And this is why you had the fact pattern involving the case you heard about. So when a common or usual name has not been established for a food by means of a standard of identity, and in those very few cases where FDA has actually written a rule assigning a name for a non-standardized food, this is the rule that we would look to give the principles for how to come up with a common or usual name. When I read this, I often think about canned peaches, because think about how many details you have to put in the name of a canned peach. You know, heavy syrup, light syrup, juice. What is it packed in? Is it a peach half? Is it a peach slice? Is it diced peaches? We know it's a peach. We know it came from a peach tree, but there are a lot more details that are required to meet that standard than telling me it came from a peach. So it says it has to accurately describe, identify or describe. It must be uniform among all identical or similar products. Each class or subclass of a food shall be given its own common or usual name in a way that distinguishes it from other foods. And then we have the imitation labeling rule. And while the statutory language is broad, FDA regulations in this area have been amended over the years, and it's a fairly narrow rule at this point in time. The only time that imitation labeling is required is if you are, substituting. It's a non-standardized food that is substituting for a standardized food. And so we get into this zone when we are using a term like milk to name a non-standardized food, and it only applies if it's a nutritionally inferior version, as I said before. I think I covered that before, so I will move on. So one of the points I really want to stress here, because, you know, I too am a big fan of the First Amendment, but I think one of you mentioned that I'm a dietitian and I have a master's in public health. And one of the things I truly appreciate about standards of identity is the fact that they have had a tremendous public health impact in preventing diet-related diseases. And we aren't done yet. I mean, there are a lot of diet-related diseases, but you never hear about certain diseases like rickets. And we're starting to hear about it now because there are people who are not getting enough vitamin D. And a lot of the milk, while it's an option to add the vitamin D, a lot of the milk in the marketplace is fortified. And so, we can thank fortification and the fact that we have a standard of identity, because if you're going to do a public health intervention, you need to make sure that the nutrients are going to be delivered at an amount that is going to meet a need, but not too much. And so you can regulate that and keep it within limits by having standards of identity. So thankfully, we don't deal with rickets anymore. And then how about this one? Pellagra. People hardly even remember pellagra, but pellagra, in the year 1928, it was a disease that affected rural Southerners. It started to emerge in the early 1900s because they didn't know much about nutrition. They first thought that it was an infectious disease like COVID-19. And eventually they figured out that it was a niacin deficiency. Now you can see one of the visible signs, which is a terrible dermatitis, but this was actually a lethal disease, and it also caused dementia. And so soon after the 1938 Act was passed and FDA got this Section 401 authority, they created standards of identity for grain products that included the fortification with B vitamins, including niacin. This is why we do not have pellagra, beriberi, we have less anemia. It's because of that package of nutrients that are essential for our bodies that are put into the grain products. One thing I want to point out to you about this is that, you know, the foods that get fortified are basic foods that are consumed by large sectors of the population. These are folks who, you know, includes people who may not care about nutrition, may not want to buy dietary supplements. It has a reach that crosses socioeconomics and so forth. And so it has many strengths in that regard. And then just so you know that this is not ancient history, in 1998, folic acid was added because there was the discovery that spina bifida and other neural tube birth defects were caused by inadequate folic acid intake. And this is a B vitamin. And one of the tricky things about this is that this is a birth defect that happens so early in pregnancy that a woman typically doesn't even know she's pregnant at the time it's happening. So, you know, the prenatal vitamins are not going to be of any help. You have to have it in the diet when the person isn't even planning to get pregnant. And this is of course, it's a crippling disease. It affects the spinal column, and it has, affects some of the people who have it are paraplegic. Some develop hydrocephaly, which is what you see with the baby with the large head. And we've had a tremendous decrease since the fortification occurred. And there's a room to expand the fortification and do better in reaching some populations. But what I want you to understand is that these are important regulations that are not just about the immediate issue of whether a consumer knows, you know, whether it came from a plant or an animal, but they have another purpose that has to do with the integrity and nutritional quality of the food supply. So there's consumer health and public health issues in addition to consumer deception issues to consider. So now let's talk quickly about First Amendment. The disclosure requirements that the petition is asking FDA to enforce and to codify in clearer rules. All of these involve the disclosure of accurate, factual, and uncontroversial information within the meaning of the First Amendment case law. The disclosure requirements are designed to distinguish foods that comply with standards of identity from those that do not, and to do so in a manner that fully accounts for whether the substitute food is a nutritionally equivalent or nutritionally inferior food, and to prevent the consumer confusion and deception that comes from a sense of a false equivalency when the standardized terms are used. And the link beyond consumer deception goes to consumer health and public health. And these are areas where it's, you know, not at all in dispute that the government has a substantial interest. The disclosure requirements are carefully tailored. They're narrowed. They're triggered only when a non-dairy food is a substitute and it uses the name. There's a lot of things that have to happen before this is triggered. Imitation is a term that FDA has defined based on case law interpreting the term over the years. And they very specifically limited it to nutritional inferiority in order to tailor it as closely as they could to the objectives of the standards and the related imitation labeling. There is no question that combining a plant name with a standardized term is a wholly inadequate way to comply with FDA common or usual name requirements. I just mentioned canned peaches a little while ago to give you a sense of that. But in this context, it's all the more. It's inadequate to prevent the consumer deception or advance the interests. And even if we account for the information on the information panel, which typically you're not allowed to do in a deception case, you can't cure deception by making someone turn the package over. But even if we go there, you know, the ingredient statement and the nutrition facts box were not designed for this purpose. The information in there are some indicators of nutritional inferiority, but the nutrients that are in the nutrition facts box are just a subset of those that are considered to have public health significance for the general population. They are not a disclosure of material facts comparing two products. And the same is true with the ingredients. You know, my own view here is that we don't want consumers to have a master's degree or a PhD in nutrition or to figure out how to live their lives and follow dietary guidance. And, you know, these products are packaged in packaging that looks like dairy products, and they're in the dairy case. It's not like coconut milk sitting in a little, you know, shelf-stable can. It's not like body butter I put on my legs. You know, we're talking about some intentionality here in positioning this to be a substitute for standardized dairy products. I mentioned that the dietary guidelines only recognize fortified soy as even being anywhere near the nutritional quality of dairy products. And I just want to point out that, you know, the plant kingdom is a very diverse place. You know, some plants are good for salad, you know, and some are good for making an alternative milk like soy. I think that it's just not going to fly that you can, you know, fully disclose the differences by just giving the name of the plant source.
Sarah, I just want to jump in and pull Claudia in for a moment since we're getting close to the end of the hour. We'll get back to you in a second, but, you know, Claudia, I want to, you know, give you a chance to ask some questions or pose some thoughts about where these differing views fall in terms of current doctrine. You know, we had the NIFLA case that was decided just last term about, you know, what standard of review applies to regulations like these. And in particular, you know, these dietary standards, these standards of identity that Sarah explained go back, you know, federally, you know, almost 100 years and even longer than that at the state level. I found this morning an Ohio law from 1886 that said you can't use words like butter and milk and cheese to refer to non-dairy products. So, you know, how does that fit into the doctrine as it stands currently?
Jonah and Claudia, if I could interject just a moment, I'll give the code for CLE. It's the letter M, the letter B, the letter N, the letter S, 03. So MBNS 03. And take it away, Claudia.
All right, thank you. So my job on this panel, I guess, is to sort of contextualize and complicate these issues a little bit. In the interest of time, I want to do that by mainly circling back to...
How about if I escape from this screen?
That would be great.
So we can see everybody's face.
I think you go up to the menu and you say stop sharing. There we go.
Excellent. So...
Good.
All right, so basically what I want to do is just go back to, circle back to the panel this morning. It was really excellent in laying out the doctrinal landscape. So I don't want to repeat that much. I just want to sort of underscore what the panelists on the first panel said about the historical development, the broadening of commercial speech as a category, also developments across different neighborhoods of the First Amendment. And so, Sarah, I saw that the last slide you pulled up actually was about Zotterer, and that's great because that's one of the things that I would like this panel to consider, and that is sort of the relationship between Central Hudson and Zotterer, which is something that the panel this morning already teed up. The other thing I just want to flag is this move from a listener focus to a speaker focus. Again, I don't really want to add too much to what was already said this morning, but maybe if we can take that perspective to the cases that you've just presented. And then finally, there was this larger theme of the deregulatory, the sort of Lochnerizing move that was also discussed. I just want to flag that also maps on to this discussion we're having now. So again, if you're around this morning, you'll remember this discussion about sorting speech into different buckets and then deciding what level of scrutiny applies. I would actually try to get away from the sorting and standard of review conversation and sort of take a step back, ask why government regulation should be scrutinized in the first place. And what makes this discussion on this panel particularly useful is that we're in a space where public health and safety considerations could provide a basis for regulation, right? And so then what I want to do is just pose a few questions that'll allow us to kind of draw out the themes from the first panel in the morning, from the sort of landscape that I just sketched very briefly, and see how your presentations of these case studies fit into that. So one thing I'd like you to sort of talk about a little more is unpack the various ways in which harm could result. So Sarah, I think you said a lot about the sort of the health benefits and dangers. I'd be interested to hear what Justin would say to that. So one dimension is the sort of health benefit danger. To what extent do you think permissible regulation for First Amendment purposes should align with potential harm? The other question I would be interested in is, what do you think about expertise, right? Whose expertise should factor into this? So again, Sarah just talked about nutritional science. It'd be great to hear Justin's response to that. And then shifting to something that Justin flagged, right? He said something like, let folks call it what consumers understand. And so, what does that mean? So what if everybody knows what soy milk is or what tofurkey is, but not everybody knows what an Impossible Burger is? So how would that play out? And then again, coming back to your Zotterer slide just now, so perhaps talk a little bit about this line between permissible and impermissible compelled speech as distinct from this naming products story that you were just explaining. So how is it different? or not, right, for First Amendment purposes, which I believe, Sarah, is where you were going with your last slide. So you might.
Well, I had several. I just had the slides that showed the cases, the key cases that were supporting the position. I'm happy to comment briefly if you'd like.
Yeah, those were actually my big theme.
Okay, yeah, your point about the neighborhood. Your point about the neighborhood, I think, is an important one, if I'm understanding it right, because I think I was pretty clear at the beginning in stressing that this petition is only about dairy. And one of the things, I know that Justin's involved in some meat cases, and so meat alternative cases, and one of the things that, these policy considerations I've talked about are more closely tied to some foods than others. And there are logical reasons. It has to do with the evolution of food and drug law and when we got certain amendments and such and so on and so forth. So we're getting rid of the cherry pie standard. And what I said today does not relate to the cherry pie standard, okay? But when we're talking about dairy products, we're talking about something that is important from a nutrition and dietary guidance standpoint. And so the cases that I look to, I think that in the area of food and consumer products, that the court is actually, the trend line is a little different than where you find in other places. There seems to be a growing appreciation to get away from this notion that disclosures are just about deception. That when you're selling products, they have to fit into that person's life, the consumer's life. So I think about sort of directions for use for mercury light bulbs. And I think there's some things that consumers, the expertise goes into the design of the product itself, and that might be where we are. But I think that, this idea that was in the AMI versus USDA, I like this concept of thinking about Central Hudson and Zotterer really being in alignment as opposed to different standards. That when you're talking about certain kinds of speech related to consumer products, some of those elements have already been satisfied.
I'd actually love to jump in on that because I love it when there are places where Sarah and I can agree, and I'm sure there are many of them. But I don't totally subscribe to the view that Zotterer is just Central Hudson with some of the elements satisfied. But what I will say, and it's not that different than this, is the way NIFLA clarified Zotterer in the second half of the NIFLA opinion. It made it really clear that Zotterer had nothing to do with the rational basis test, as some circuits had claimed, but instead it was a lot more like the Central Hudson Review, where it was a meaningful, usually evidentiary burden on the government, and where they had to independently meet several different prongs, and if they failed, even the compelled speech would be unconstitutional. And I think that's a really important point. I mean, I think so often we get bogged down in which test to apply. And that's important, especially as a litigator. Like I spend a lot of my time telling judges which test I think they should apply. But I got to tell you, when I read that part of NIFLA, the thought that came into my head was that the difference between NIFLA and, the difference between Zotterer as clarified by NIFLA and the Central Hudson test, that's not a huge evidentiary difference in terms of the impact on most practical cases, right? The biggest part of many of my cases is fighting over whether the rational basis review applies, in which case all of the burdens are on the plaintiff, and in fact, ridiculous burdens are on the plaintiff, or whether the burden's on the government. And now it also matters what level of burden's on the government, but that oftentimes matters less than who bears the burden. There are times where as soon as I get the government to say that it's a free speech case where there's some level of burden on the government, instead of the rational basis test, the government lawyers will throw in the towel and say, wait a second, you mean we have to prove that this law does something beneficial for society? We can't do that. And they'll give up. And so one of my big concerns was that the Supreme Court might adopt the view at some point that some of the circuits had adopted that really treated Zotterer as nothing more than rational basis review. NIFLA clarifies that that's absolutely not the case, that NIFLA, that as it clarified Zotterer, places at least a meaningful evidentiary burden on the government, which makes it nothing like the rational basis test. And it means most of the time, if the government's able to meet its burden under Zouder, it's probably going to be able to meet its burden under Central Hudson. And if it's not able to meet its burden under Central Hudson, it's probably not going to be able to meet its burden under Zouder. There are going to be some cases that fall, in between, but they're, I think, remarkably small.
Well, let me just say that I find it quite fascinating that you think that NIFLA clarified anything.
Well, it could have been clear, don't get me wrong, but on that point, when it comes to the fact that Zouder is not the rational basis test, it was very clear about that. It wasn't clear about some other things, but it was clear about that one.
So, but that's sort of the government throwing in the towel story, right? That I think is a useful thing to think about, going back to the harm question I asked. So is it that they're throwing in the towel because they can't come up with a good explanation for what the harm might be, right? And that is the idea of, are there nutritional reasons, as Sarah just said? So maybe just sort of tie that back in.
Yeah, so I mean, just to be totally frank, that's usually not what the fight is about. Just speaking from a practical standpoint, usually the fight isn't about the substantial government interest or legitimate government interest. There are times it is, but far more often the fight is over whether the law, actually advances that interest in a meaningful way, and whether it does it in a way that's not unduly burdensome. And that's particularly true in the First Amendment case. And in fact, I basically just laid out the Central Hudson test in other words. And that's really what the fight is about, the last two prongs of the Central Hudson test. I'm not saying there's never going to be a fight over, whether there's actual harm being addressed. But those are far rarer. That usually the fight is whether this law actually does anything, and even if it does, whether it's overly burdensome.
But the harm test under Central Hudson really has a lot to do with the historical record. The harms are real, the Edenfield case, and the regulation will alleviate to a significant degree. When I look at the cases where just focus on the disclosure cases, the disclosure requirements are meeting the test, whatever we want to call it. I'm thinking of the National Electric Manufacturers versus Sorrell. I'm thinking of New York restaurant. These are broader, the environmental protection, obesity epidemic, public health. And they're coming down saying it doesn't have to alleviate that harm in a very, measurable way. It's enough that there be sort of a reasonable tailoring to it. It can be a component of the solution. And I think that is very important in this context. The other thing I want I don't want to leave unaddressed is the imitation term, because when we look at the disclosures that are being knocked down, they have a political bent to them. They have a value-laden bent to them. And so the petition goes through all of these cases, but, I'm thinking of the R.J. Reynolds case with the graphic tobacco and the 1-800-QUIT number. I'm thinking about the court said you're making the people say you've got blood on your hands with the conflict minerals, and the 18 on the sexually explicit videos. And so it's when you're crossing over, and even in the Amstoy case, there was some dicta about, aren't we getting into an area where, and I happen to agree with that, because there wasn't any science to support that particular disclosure statement. It wasn't like what we're talking about today. But I think when you start to get closer to sort of a political agenda, putting a thumb on the scale, kind of making someone argue, and now we're talking Woolley versus Maynard now, it's that kind of disclosure that is getting struck down. But in the world of consumer products, in that little neighborhood, it does seem to me that the courts are recognizing that it goes with the territory, that you're going to have to provide information to the consumer. And some of that is going to be stuff that, this might be where we differ. Some things are complex, and some people like to read the manuals. Some things just need to be built into the product.
Oh, so I'd love to jump right in and address that, because Sarah brought up a really important point that we should devote some time to, which is the whole issue of the compelled speech of the word imitation. And so let me just lay out my view, right? As far as my clients are concerned, imitation is a highly controversial term. And so right away, there's a big argument there that Zouder doesn't apply because it's such a controversial term. But let's look at it from a First Amendment standpoint also, even setting that aside, just the way that you treat, soy milk and coconut milk and almond milk and dairy milk, right? The dairy industry, and Sarah seems to be coming at it from the standpoint, and of course the regulations do too to some degree, that just because you're a different type of milk than dairy milk, that means you're imitation milk. No, there are different types of milk. As long as far as the public understands, as far as the consumer understanding is concerned, which is what the First Amendment precedent now really cares about, there are different types of milk. And the fact that coconut milk is different than cow's milk doesn't make coconut milk imitation milk any more than the fact that cow's milk is different from coconut milk makes cow's milk imitation milk. As far as the public is concerned, these are two different types of milk. And so calling either one imitation, I think would likely violate the First Amendment, because it's not that you can never compel speech, right? Like you could compel the nutrition facts panel, that would survive Central Hudson review. And there's all sorts of speech you can compel as long as it meets certain requirements. But imitation is not one of it. I would love that case.
It seems to me that you're really focused on just a very kind of advertising law type of deception concept. You're not really plugging into the public health aspect here. The only way that I can, top of my head, sort of describe what I'm thinking is it's comparable to an attractive nuisance. When you create something that's inviting someone to make a choice that is going to put them at risk, because we often talk about nutrition as something different than safety. But I just showed you some pictures of what happens when you don't get your needs met nutritionally. It's, not something to negotiate with. And so I think that the public health considerations deserve more weight. Now, back to the point, each and every standard is not the same. So some, like cherry pie, we're eliminating that one. So there is that part to it. But
okay, so let me jump in there. All right. So
I'm sorry, Justin. I don't mean to cut you off, but it looks like it's 4 o'clock. So I just want to see if Claudia, you have any final thoughts that you want to close out with.
I would just kick it back to you and see if you had anything as our moderators.
All right. Well, I hope that everyone, if they drew one thing from the panel today, it's that, there are two very compelling sides to this dispute. It's not just about free speech versus protectionism, but it's about how you conceptualize free speech and and what's at risk here. And I think both sides have something really interesting and meaningful to say, and we'll see how this doctrine develops in this uncertain territory. So thank you to all of our panelists for being here today. I encourage everyone to read their writings, their articles, their Sarah's petition to get a deeper view than this short time will allow. So thank you all.
Thank you.
And thank you on behalf of the Abrams Institute. Thank you, Jonah, Brendan, this panel, and all of our attendees. It's been a really great session and a great day. Thank you all. See you next year.